I'm Neil, and I'm the teacher.
And I'm Sean, and I'm the deal maker. Together,
We're the Rise Guys.
A property manager asked one wrong question during a tenant interview. The Human Rights Commission was not forgiving. Today, I am showing you the 13 protected grounds you cannot touch in Alberta and exactly which questions put your license at risk. Let me walk you through a scenario that happens more often than you would expect. A manager has a solid applicant. The interview is going well. They ask almost in passing, where are you from originally? Then they follow up. Do you have kids? We have quiet hours here. Both of those questions, asked without any discriminatory intent at all, directly target protected grounds under the Alberta Human Rights Act. Place of origin, family status. 2 of the 13 grounds the Act protects. And here is the critical point. A human rights complaint does not require the complainant to prove the manager intended to discriminate. It requires only that the question could have influenced the decision. That is the bar, lower than most people realize and higher stakes than most people plan for. The Alberta Human Rights Act organizes its protection around 13 grounds. Think of them in 2 groups. The first group covers identity, race, color, ancestry, place of origin, religious beliefs, gender, age, and sexual orientation. These are characteristics a person carries with them. The second group covers situation, physical disability, mental disability, marital status, family status, and source of income. These are the circumstances a person is in. If a tenant interview question, even indirectly, surfaces information about any of these 13 grounds, and that information could reasonably have influenced your rental decision, you are in violation territory. The standard is not what you intended. It is what a reasonable person would conclude about what you are doing. Here's where property managers get into trouble. The prohibited questions do not announce themselves. They feel like normal conversation. Where are you from originally? A classic opener. But it is asking about place of origin. One of the 13 grounds, do you have children? Sounds like logistical planning, but it surfaces family status. How do you earn your income? Sounds like financial due diligence, but income source is protected, not just income amount. Do you have any health conditions I should know about? Perhaps asked with good intentions around accommodation, but it is asking about disability, which is protected. Each of these questions touches a ground the Act covers. And once that information is in the room and the application is denied, you have a problem to explain. Now, here's the dimension most property management training glosses over. The Alberta Human Rights Act does not just cover your tenant screening process. It covers every employment decision you make as a property manager. When you hire a building superintendent, a maintenance technician, or a leasing agent, the same 13 grounds apply. You cannot ask prohibited questions in a hiring interview any more than you can in a tenant interview. And layered on top of that, the Alberta Employment Standards Code sets the floor for how you treat the people you do hire. Minimum wage is $15 per hour. Pay must be issued within 10 days of the end of the pay period. Staff are entitled to 16 weeks of maternity leave and up to 62 weeks of parental leave after 90 days of continuous employment. Property management is not just about buildings. It is about running a people operation, and the law treats it exactly that way. So what can you ask? The lawful framework is actually straightforward. You can verify the ability to pay, but ask about income amount, not income source. A tenant's rent to income ratio is fair game. Whether they earn it from employment, disability benefits, or a trust fund is not. You can ask about rental history. References from prior landlords are entirely appropriate. You can run a credit check, but only with the tenant's written consent. And you can ask about intended use. How many people will live in the unit and for what purpose? Here is the critical habit to build. Before you start any interview process, write down your selection criteria, apply them consistently to every applicant who comes through. Keep a record of why each decision was made. That paper trail is your defense if a complaint is ever filed. Consistent documented criteria show that the decision was made on lawful grounds, not prohibited ones. Let me give you the protocol that protects you. Before any tenant interview, write down your selection criteria, credit threshold, income to rent ratio, reference requirements, write them down and apply them the same way to every single applicant. Remove any question from your intake process that touches a protected ground, even the ones that feel like small talk. Verify income amount, not income source. Get written consent before running a credit check. And if a complaint is ever filed against you, that documented history of consistent criterion-based decisions is your evidence. It shows the outcome had nothing to do with a protected ground and everything to do with the criteria you applied to everyone. The Alberta Human Rights Act puts the burden on the property manager to demonstrate the process was lawful. Your documentation is how you carry that burden. Get the process right before the interview starts. That is the show for this week. I will see you in the next one. New webinar summary every week. Subscribe so you never miss one.